call Claire Curran.
Thank you, Mr Speaker, and Happy New Year to you and to everyone in the House and across Parliament, including all the staff. Mr Speaker, as the only, perhaps the only speaker on this bill tonight who actually sat in the Select Committee from 2009 through to 2013, when the Patents Bill, which is the bigger bill, which this bill is essentially part of, sat through all of the hearings, the debates, and then the big drama that ensued in ensuring that it passed in a way that did not suppress our innovation in this country. I think that it's good to bring a little bit of historical perspective, and I want to just go back a bit, nearly 10 years ago, to when this bill had its gestation in a process which began under the previous Labor government, which was ultimately about wide-ranging reform of our patent system and the Patent Act of 1953. And that's quite a long time ago, well before I appeared on the earth, and presumably most people sitting in the chamber tonight. Not all, but most. And the Patents Bill was tabled in 2009, and it included a provision in that to update and modernise our registration requirements for patent attorneys and align New Zealand's regime with that of Australia. Now, it's useful for people to know, and they may not have sort of worked that out tonight listening to the debate so far, that this bill that's been tabled is not a new bill. Well, it is a new bill, but it's not. It has its gestation in a previous bill that sat on the order paper for a long time. But by the time that this bill, the bigger bill, made its way back to Parliament in 2011, the Select Committee then recommended that that part of it, which was about the modernisation and updating, actually be separated because there had not been a single Trans-Tasman framework for regulating patent attorneys established, even though it had been signalled by both the New Zealand and Australian governments. But it couldn't be included in the bill at that point because the framework hadn't been established. So that's what we're seeing here tonight, and Labor's certainly supporting that to Select Committee and see no problem with that in theory, and because streamlining is a good idea, that the modernisation and updating of this regime is clearly important. It's 1953, it's now 2016, and supporting efficiencies in the patent process, and again, as my colleague Clayton Cosgrove said, that the alignment of the jurisdictions. We have no issue with that. We had no issue with that in another piece of legislation that went through the Select Committee last year on accounting standards and how they operate. And so that's a good and sensible thing to do. But I do think it's important that a bill that comes to the House, that you do actually hear its history, and that it was part of a bigger bill that did pass through the House in 2013, and it has sat waiting until that streamlining framework has actually been established, which is now occurred. I do, however, want to express a concern. It's not an outright concern, and my hope is that though any fears will be allayed when we get to Select Committee. But I do want to express a concern with one of the aspects of the bill. And the explanatory note, the first part of the explanatory note says that that an issue, that since the Patents Act of 2013, the bigger bill, entered into force, that an issue has been identified with the grounds on which third parties can oppose the grant of a patent on an accepted patent application. And Melissa Lee just referred to that before. The question I have is, though, who has expressed the concerns? Where are these concerns have been expressed? I didn't hear the Minister allude to that, what the concerns are. All of the information that I can find out about this bill doesn't go into any detail about that. They all use exactly the same phraseology around that. And it talks about the fact that, as enacted, that there's, there has been some kind of drafting error, it was described somewhere, in the Patents Act 2013, which allows a grant of a patent to be opposed on the ground that an accepted patent application claims patent protection for more than one invention. And that's described as, and it's jargon, but it's described as a lack of unity of invention. And it then goes on to say that there was no policy intention to introduce lack of unity of invention as a ground of opposition in the Patents Act 2013. Well, Mr. Speaker, I sat on that select committee, and perhaps it is a stuff-up, perhaps it is a drafting error, and if that's the case, then that's fine. But there were reasons, and I want to go back. I want to go to the intent of the Act, the bill that came back to the House in 2013, and just draw the House's attention to what it said. And it said, and this is paraphrasing part of the commentary on this bill, it said that, this is the Select Committee, we think that the grounds on which third parties can oppose a patent being granted, request that a grant of patent be re-examined or request that a patent be revoked should be consistent, and recommend the clauses, amending the appropriate clauses of the bill to achieve this. It said that many submitters favoured pre-grant opposition and argued that it allowed New Zealand businesses to limit the scope of troublesome international applications, and that an opposition mechanism allows overly broad patent claims to be narrowed, preventing patent owners from wrongfully asserting invalid rights and thus reducing the costs and disruption to business. Well, what that is shorthand for, Mr. Speaker, is this thing called patent trolls. And patent trolls are endemic in the United States. They're an industry unto themselves. They do not produce anything. They do not add any value. All they do is litigate and create barriers and to innovation and huge costs, and they result in businesses, small businesses, particularly innovation businesses, going under. And my concern is, well, what is this drafting error? What the intent of the Select Committee, and we spent a lot of time discussing this in the Select Committee, is what impact that will have on the putting up the barriers to patent trolls. So the whole point of having third-party opposition to patents was to provide a mechanism for there to be, to ensure that there couldn't be rampant patent troll activity. And just to give you a sense of the extent of patent trolls, and most of them come from the United States, and it's important that people know that, where the litigators, the attempts to try and prevent innovation occurring and companies achieving a patent come from the patent trolls. And in 2015, more patent lawsuits were filed in the United States than any other year, save one, buried beneath heaps of high-tech lawsuits led by patent trolls, shell companies with no real assets other than patents, and about 2/3 of all patent lawsuits were filed by patent trolls. Mr. Speaker, hopefully those fears will be allayed in the Select Committee. I am raising that concern because I do hope that the history of this bill, the importance of patent reform, is not being reinvented, and that we are not going to, open up New Zealand businesses trying to achieve patents to risk from that patent troll regime.